Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Elloian. Our show topic today is gerrymandering and your vote. Our guest is Dr. Daniel Breen. He is the Senior Lecturer on Legal Studies at Brandeis University. Dr. Breen holds a PhD in American History from Boston College and a law degree from the University of Georgia. Let's welcome our guest. Welcome, Dr. Breen.
Great to be here.
Now, today our topic is the U.S. Supreme Court and the recent rulings on voting rights. Can you give us a little synopsis on gerrymandering? We did a program before, but I want to catch everybody up to speed. Give us a little synopsis on gerrymandering, what it is, how it works, and its effect.
Well, gerrymandering is very common in our system. This has been around since the 18th century. There was a famous incident, for example, when they actually tried to gerrymander James Madison out of one of his seats to no avail. And all it really amounts to is state legislatures trying to draw district lines for future congressional or state legislative elections that give them some sort of partisan advantage. And there could be many reasons for the partisan advantage and many motivations. But the basic idea is you're manipulating the district lines of legislative districts to give your party an up in the next election. And as I said, they've been with us forever. What a lot of people don't remember, though, is that for much of our history, up until the 1840s, we didn't have single-member legislative districts routinely, at least for the U.S. Congress. And that meant that states were free to elect entire slates of candidates just from the state as a whole. So if your state had 8 Congress people, then you could just elect all 8 on a statewide basis and have no districts at all. And there was no role for gerrymandering at all in that kind of system. And that's why it wasn't such a big deal until 1842, when Congress enacted legislation that said all seats have to be from single-member districts. And that's when gerrymandering began to be a really live option, even more than ever before. It was a big problem in Reconstruction, as Southern states in particular tried to draw legislative lines to discourage Black voting power. And one of the tragic ironies of the case we're going to talk about today is that one of those districts in central South Carolina that this modern Supreme Court case was all about was a district that was gerrymandered all the way back in the 1870s to pack Black votes into one particular district so they couldn't elect that many Congress people from the state as a whole. Gerrymandering continued into the 20th century. The very big decision that began to put some limits on it, although maybe not as dramatic limits as a lot of people would like, was the Baker versus Carr decision of 1962. And that's the decision that said, whatever else legislators do, every single district has got to be roughly equal in population. And so today, every single district, congressional district in the US, other than one-member states like Wyoming, which there's not much you can do about them, but in any multi-member district in states all across the country, the population has got to be about 790,000 based upon the US population today. And that brings us to the case for today. And the case for today, out of South Carolina, it's officially Alexander versus NAACP, because Alexander happened to be the president of the state Senate of South Carolina, and that makes him the defendant, is all about the need to make sure those districts are equal in number. That's how the case came about, because of demographic events in South Carolina.
So basically, it's South Carolina versus the NAACP.
Yes.
Alexander was just the proxy for the case to be brought.
He's the named defendant. So if you don't like the case, his is the name that will live in infamy. But South Carolina is really the defendant, so we probably ought to refer it along those lines. And the basic problem in this case is that in the first couple decades of the 21st century, one particular district in South Carolina was growing even more than any other part of the rest of the state. And that's the part of South Carolina that I'll bet a lot of our listeners are familiar with if they travel down there, and that's the Low Country. All the area just to the east and just to the west of Charleston, which is mostly in one district, stretching from the area around Savannah all the way to the area just around Myrtle Beach. And that's the first congressional district of South Carolina. And that district was growing by leaps and bounds, well over that 790,000 threshold by 2020. And that meant that after the census of 2020, South Carolina really had no choice. They had to do something. That district was just too big. So it wasn't as if they just out of thin air decided to do this. They were under a mandate to make sure those districts were equal. And that meant the main thing they had to do was find a way to draw population from the first district that was overpopulated, a district that was represented, still is, by Nancy Mace, one of the most, if not notorious, at least well-known Republicans in Congress. And the way they were going to do that, and the obvious way to do that, was to put some of the voters in District 1 into a district that was relatively stagnant in population growth, and that was District 6, which encompassed part of Charleston, but mostly the area to the north of Charleston, stretching up towards almost the suburbs of Columbia, a pretty big central South Carolina district. Now that District 6, which is what it was called, is historically, if not a majority African-American district, at least something very close to it. I think in the last census, 49% of the voters there were African-American.
Well, that's a big majority there.
It's
almost half.
Yeah, almost half. And in the past, it was more than that. But demographics being the way they are, now it's about 49%. Because they had so many Black voters, voting patterns being the way they are, they typically elected Black congressmen. And they were represented for 30 years, I think, by Jim Clyburn, another very famous member of Congress,
right,
and a leading ally of President Biden. So what was going to happen, one way or another, was voters from District 1 were going to go into District 6 to equalize the population. Now, the whole case is about how it was that the state Senate of South Carolina, responsible for making these apportionment decisions, decided to go about it, like how they actually did it. And the easiest way to do it, the thing that would occur to you and me, would just be to look at the border areas around District 1 and maybe just randomly over the course of District 1, take some of those areas and put them in District 6. And you could do that relatively easily, just take equal parts of various parts of District 1 from north to south, and then put them in District 6 where you could. And if you had done that, if that had been done, and this was clearly in evidence in the case, then what would have happened is that the African-American percentage in District 1, typically referred to as BVAP, Black Voting Age Population, that percentage would have gone from what it is now, about 17%, to something closer to 20% or 21%. So if you'd done it randomly, which would be the easiest thing to do, to keep everything contiguous without very much disruption to living and voting patterns on a residential basis, you would have had a higher Black percentage population in District 1. And that might have made things a little bit tougher for Nancy Mace, the Republican. And we know that because although District 1 was only, and still is, only 17% African-American voting age, some of those races could be competitive in District 1. In fact, Democrats won District 1 as recently as 2018.
So I think what you're saying is that if it was more, there were more Black voters, they would vote more Democratic. Is that what the research shows?
That's what the research shows. That's certainly what voting alignment tends to be in South Carolina and to the rest of the South. And there was no doubting that. Like nobody ever brought up any contrary evidence to that presumption. So everything
and they knew this.
Oh, they knew this. They clearly knew this. So they didn't do the easy thing, which is what maybe you would think they would do. What they did was they sat down with computer analysts and election experts, people who do this kind of thing before, looking at residential patterns very, very carefully. Using
something the founders never had in mind, right?
No. They weren't thinking of computer algorithms and Philadelphia.
Okay.
So we have all this technology now where almost down to the street level, you can figure out voting patterns, residential patterns, where people living, especially racial background of people and where they're living. And they used all that information plugging into a computer program and they found ways to transfer largely African-American voters from District 1 to District 6. Now, they had to transfer about 87,000 voters to make it equal. Now, the curious thing is that what they did was they took heavily African-American areas in North Charleston and in general Charleston County, and they moved over 140,000 people, mostly from those areas, into District 6, which is much more than they needed to. And then they moved some voters from District 6 into District 1. And if they're just going to equalize the population, why would they be moving anybody from 6 to 1? But that's what they did.
Suspicious, very suspicious.
Yes. And what they ended up doing, also very suspicious, this is hardly a coincidence, is they ended up, after all these people had moved around, a total of 140,000, they ended up with exactly that 17% Black voting age population that they began with in District 1. Here's the very curious thing about that. It sounds like a coincidence that can't possibly be a coincidence, and if that's what you're assuming, you're right. But here's the other really interesting thing about that. The plaintiffs in this case, the NAACP, they had experts come in to run their own computer programs. Who else could go into District 6 from District 1? All the different things that could have been done. They ran thousands of simulations about other ways to take people from 1 and put them in 6, so you have even population. And none of those 1,000 simulations came out with precisely the 17% number that South Carolina came out with. All of those simulations that the plaintiffs ran came out with a higher Black voting age population in District 1 than what South Carolina ended up with, which means all this was intentional. And we know it was intentional, not just because of those simulations, which is pretty damning evidence in itself, but also because of the defendant's own testimony. South Carolina came in. They had their experts come in and testify at the trial, which you would expect they would do. And
Right.
they made it clear that whenever they would go through their own simulations, they had the racial outputs in front of them. So they knew exactly where people were living based upon race, and they knew exactly where or what their racial breakdown would be, depending upon each line that they might have drawn and that they were considering. That would just pop up in their computer simulation. So there's absolutely no doubt at all about the fact that they took race into account. They had it right in front of them on their computer screens. And that is why, not surprisingly, the NAACP challenged this whole thing. So what you end up with is, I think, 62% of Black voters who had been in District 1 in North Charleston now ended up in District 6, is heavily concentrated in that particular demographic. And
so the result is their vote got diluted by the Republican votes. Is that correct?
yeah, so the argument would be that the effect of this is to dilute the potential of Black voters to elect Democratic candidates in District 1. And the evidence for that seems to be pretty strong. The question is, though, what was the motivation of the South Carolina legislature? And here is where we get into the real problem with this case. We'll talk about this maybe a little bit later, but this isn't a Voting Rights Act case where voter dilution would be the primary issue. This is an Equal Protection Clause case. At least that's what the ruling was based on. And that means all you got to look at is the question, was the motivation that produced this particular map in South Carolina predominantly racial in intent and ultimately in result? But the main thing is, was the motivation predominantly racial in nature?
Can you just tell us for a moment why this case wasn't under the Voting Rights Act at all, and why it was an equal protection argument?
Yeah, so the reason it's not going to be a Voting Rights Act case is that South Carolina now is 25% African American in terms of voting age population, and there are 7 congressional districts in South Carolina. And that means, at least the way things are now, South Carolina is under no obligation to have anything more than one majority Black district or something close to that, which is what District 6 is. So they're under no obligation to enhance Black voting power in District 1 or anywhere else. And to be more precise, because the 17% level is still the same as it was before, the argument is pretty difficult to make that it's a voter dilution case. Blacks, arguably in District 1, aren't any worse off than they were before this change. Now, the argument could be that potential power has been diluted. They're not up to 20% where they could be, or 21% where they could be. But so far, at least, that's a pretty slim Voting Rights Act case.
Yeah, I think the reason being the Voting Rights Act has really been itself diluted. It's been cut back, and many of the provisions that would have applied no longer apply. Is that correct?
Yeah, part of the Voting Rights Act, just as you said, is effectively a dead letter because of the Supreme Court, which was pretty important in this case, because the old Section 5 of the Voting Rights Act would have demanded that South Carolina submit this plan to the Justice Department before they ever put it into effect. And the Justice Department might have said at that point that you could do better with District 1. That would be at least a potential argument the Justice Department could have made. But that was not part of this case because they didn't need to submit this to the Justice Department. The Holder case read Section 5 out of the Voting Rights Act. So we're left with Section 2. And Section 2 is a classic voter dilution element where, as long as you can't effectively have a second majority Black district, and as long as you're not, based upon facts on the ground, making things worse than they already are, Section 2 is a difficult claim to make for the plaintiffs. Now, I believe there's still a Section 2 element in this case that the lower court has got to figure out. The Supreme Court only based their ruling on the Equal Protection Clause. There may still be a Section 2 argument to be made. But I would think it's not going to be an easy one to make because the voting levels stayed the same and did not actually go down to 15 or 14% or something like that.
Now, from what I understand in reading the case, they start with the U.S. Supreme Court starts with the presumption that the legislators had good intentions in mind.
Yes, well, I'm glad you brought that up. Before we even get into the ruling, there's this very curious proposition that in ruling against South Carolina, the district court down there in Charleston failed to assume that the legislature was acting in good faith. And apparently, especially in these election cases, voting cases, you've got to assume good faith on the part of the legislature, which means you begin with the presumption, at least according to Justice Alito in the case, that the legislature was not acting under a racist motivation. Why on earth, as a general proposition, would you ever assume a legislature is acting in good faith? This strikes me as something that runs contrary to what judicial review ought to be all about. We're a lot safer in a democracy assuming they're not acting in good faith. And that's how you assert constitutional values. That's how you make them meaningful. But in this case, we begin with Justice Alito's startling pronouncement that in a case like this, in this particular case, we, the Supreme Court, don't need to do what we would usually do, and that is to give a lot of credence and weight to the findings of the district court on appeal. We don't need to do that because they didn't do what they're supposed to do, which is assume the legislature was acting in good faith. And from that proposition, that to me runs afoul of what the federal courts ought to be in our system, we eventually get everything else in the ruling, with South Carolina winning what many people thought was an unexpected victory.
Now, Lady Justice is supposed to be blind and not having a presumption going in. So this is upsetting the whole idea of, justice being even-handed.
Well, to me, it upsets the whole idea. And if they're going to presume good faith on the part of the legislature, if that's really what they think their role is, they at least ought to be consistent about this. They didn't assume good faith on the part of North Carolina and the University of North Carolina when they ruled against a certain amount of race preference and admissions. And that was only back in 2023. That was just the term before. So they assumed, in fact, if you read that case, all the way through, they assumed North Carolina was looking for some kind of racial percentage. And they didn't like that one bit in admissions. So if they're not going to assume good faith there, why assume good faith in South Carolina? And why especially do that in election cases where democracy is at stake more directly than in any other kind of case?
Isn't there any precedent in this? I mean, this assumption going in, isn't there any other precedent besides that other case in this case about going into with, with pre-thought?
There were prior cases, one from North Carolina, Cooper versus Harris, another gerrymandering case where the court paid lip service to that idea. We can't just assume racism on the part of the legislature. But that was by no means a crucial part of the ruling. This is something that I think Justice Alito latched onto based upon something South Carolina kept saying in its briefs, that's what the district court did wrong. They didn't assume good faith on the part of us. He didn't need to use that language at all. He could have done what I think most justices would do and simply go to the
fair justices. Fair justices. Yes.
Yeah, fair justice. What they're supposed to do is give credence and weight to what the district court did. And they ignored those fact findings and they got straight to the point, assuming good faith on the part of South Carolina. We cannot assume that their motivation was predominantly racial. Instead, according to Justice Alito, and this is the heart of the opinion, it's a 6-3 opinion on predictable ideological lines. The motivation in South Carolina was partisan, not predominantly racial. We cannot, the court said, based upon the way things are in American voting patterns, somehow disentangle race from partisanship, race from voting patterns, because Black people so routinely, especially in the South, especially because of recent history there, tend to vote Democratic. And since we can't disentangle that, then we have to assume that in moving people around very much on the basis of race, as it would seem, the motivation wasn't racist. The motivation was partisan. South Carolina Republicans were just trying to secure and maintain an existing partisan advantage.
So partisan, okay, race, not okay.
Partisan, right? Okay, race, not okay.
Okay.
That's basically the idea.
But they used it in the algorithms. They used both.
Yes, they used race in the algorithms. They were thinking about party affiliation as well. But the idea would be that because Black voters routinely vote Democratic, because South Carolina knew that, it's okay to be using Black voters and Black residents more or less as a shorthand for partisan affiliation. And therefore, to move them around on that basis is still proceeding primarily from a partisan motivation, because race and partisan preference correlate so strongly, especially in the South. There are a few things to say about that. Maybe I'll just say one now. The disturbing thing about this case is not just this startling idea that we have to defer to the legislature because we think they're acting in good faith. It's also that without saying so, without, in my opinion, having the honesty of saying so, in saying that it's okay for South Carolina to use race as a shorthand for party affiliation, almost as a proxy for party affiliation, the court effectively overruled a major part of that Cooper versus Harris case, where the justices said, even if you're trying to claim a partisan basis, the fact is you're still looking at Black voters. You're still moving Black voters around and taking race into account. And that itself violates the 14th Amendment. You can't use race as a proxy for partisan preference. You're still looking at people on the basis of race.
Race gets strict scrutiny under the Constitution, under the Equal Protection Clause. Yes.
That's right. Oh, and I'm glad you brought that up, because if that's what Justice Alito had said, that we got to follow Cooper versus Harris, and you can't be moving people around on the basis of race and expecting that to stand in for partisan affiliation, that would violate equal protection. That triggers strict scrutiny, just as you say. And there's no very good reason to do it. They'd have to fail under strict scrutiny. You can't find any good reason to do it.
It always fails. Yes. Almost always fails. Yeah.
Almost always fails. That's not a case the state is going to win. The only way they may win, they could bring up, we had to do this on the Voting Rights Act. But no, they never had to do this under the Voting Rights Act. It's not, as we've said before, primarily a Section 2 case. So they lose. If it's strict scrutiny, they lose.
Right. So you got the Voting Rights Act, and then you say on the equal protection, this is partisan. Oh, it's not racial, it's partisan. So
That's
you're
right.
good to go. You're good to go.
Yeah. Good for you, South Carolina. Go ahead and do what you like. Partisan gerrymandering is not a constitutional problem. It is what the Supreme Court calls a political question. And that is something that has no business in the
not justiciable, as they say. So
justiciable.
basically, all these people get their vote doesn't count. Their vote is diluted. Their vote doesn't count, and the outcome, it's outcome determinative, is what it is.
Right. And so Nancy Mace is just as likely, if not more likely, to be elected at next term as she was before, because that element that might have disturbed that equation, if you just gone about things on a wholly race-blind basis, has been deprived of voters in District 1. That's right.
So they stacked the deck. That's essentially what they did. They stacked the deck.
That's what gerrymandering is all about. And Justice Alito would say, if he were here, that of course South Carolina is stacking the deck, but states have been doing that since the 18th century. Gerrymandering is stacking the deck, and they've done it for partisan purposes since the beginning of the Republic. This is just another example of it. And the court actually said at some point, we concede this may be unfair, but there's nothing we can do about it. This is partisan gerrymandering, and there's no standard that we could use to demonstrate what is unconstitutional partisan gerrymandering as opposed to constitutional partisan gerrymandering. How much partisan gerrymandering is too much, that there's no way we can decide that. So the argument would be, it's not like Baker versus Carr. Baker versus Carr, you had situations where states had not changed district lines since 1910. You had states where, in like Florida, where 12% of the population of Florida could have elected a majority of the legislature as recently as 1960. You had states like Connecticut, which had done nothing with its district lines since Theodore Roosevelt was in the White House. All that, of course, deprived a lot of people in growing cities of their rightful influence. They can't elect anybody, hardly, to the legislatures. But we can, on the basis of equal protection, decide on a standard that will make things fairer, a real easy justiciable standard. And that is what became one man, one vote. So
right.
all the districts have to be equal. But as long as they do that, go ahead and be partisan.
So how do we fix this? I mean, I think you had some ideas when we spoke.
I do. I have a couple of ideas. And one of them is the idea that's already been tried in a number of states, and that is where you take things out of the legislature when it comes to setting where those district lines go, and you leave things up to independent commissions. And those commissions work pretty well as long as you've got equal numbers of Democrats and Republicans with somebody totally independent to break the tie. So they decide where the lines go, and they usually do things based upon neighborhood and geography and what ought to go into district lines if you were just thinking about what they should amount to off the top of your head. Only a few states have that system now, a little bit less than 10. But those independent commissions do pretty well when they're given a chance. And the crucial thing that makes them work is that the legislature must adopt what they say. As long as that's true, the governor and the legislature must adopt what they say. You've got good geographically contiguous districts where partisanship doesn't come into it. And you have slightly, or if not slightly, maybe even more than that, more competitive races every 2 years for Congress.
What about ranked choice voting? Is that an option here?
Yeah, another option is ranked choice voting. And you could do that district by district if you want. And that would mean that unless somebody gets a majority in the first round, then everybody having ranked their choices among 3 or 4 candidates would find themselves with some power, even though they might have voted for the last person down the list. That means maybe their second choice is now factored in to whoever might win. And if somebody gets a majority, then fine. If not, they go to the next candidate. And if you did it that way, then you'd have more people that don't feel left out of the process, and maybe more people participating at elections, and you could have fairer results that way. I think if you were going to adopt ranked choice voting, the way it would work best is if you did something which might take an act of Congress to allow, but it's still, I think, a good idea. Go back to the way things were before 1842 and allow states to have not 8 or 9 districts based upon their population, or 7 like South Carolina does, but maybe what about 2 districts? And in each of those districts, you'd have ranked choice voting. And each of those districts could elect more than one member of Congress. And if you did that by ranked choice voting, that would mean that you'd have a much more representative congressional delegation. You'd have minorities who could probably elect representatives based upon their numbers, rather than the way it is today, where often they're shut out entirely, depending upon where those lines go. So you could have ranked choice voting in a limited number of districts with multi-member districts. And then you'd have a fairer, more representative House. I don't know if that will happen. However, I am heartened by one thing, and maybe our listeners can feel their temperatures rising as we talk about this South Carolina case. I know I get upset about that South Carolina case. A lot of people are upset about partisan gerrymandering.
They are. They really are, especially when you these challenges went in with all kinds of maps and experts.
No. And what just happened, this should give us some hope. What just happened in Wisconsin was that a terribly gerrymandered partisan map was finally changed under immense public pressure by the Wisconsin legislature, also judicial pressure under the state constitution, as a matter of fact. You had a situation in Wisconsin where the Democrats had 53% of the vote, I think in 2014, and they only had 30% of the seats in the legislature. And that would strike any fair-minded person as unfair. And after a lot of controversy, after a lot of yelling about it, and finally after a state constitutional case, just this past February, the Wisconsin legislature gave up and they agreed on a fair, non-gerrymandered map that was signed into law by the governor just a few months ago. And popular pressure aligned with a state Supreme Court that's willing to interpret its own constitution, maybe in a different way that the Supreme Court interprets the federal constitution. And maybe you could change things that way. So we have 3 possibilities here: independent commissions, at-large ranked choice voting. A third choice would be popular pressure that just makes legislators think twice about doing this kind of thing. And then there's a fourth choice. And I don't know if you've thought about this, but why not increase the size of the House of Representatives, which has not been increased since, I think, 1912 was the last time. So we've got a country that is more than twice the population than it was in 1912, but we've still got 435 members of the House of Representatives. That makes no sense at all. And to give you a comparison, Great Britain is 1/5 the size of the US population, but their House of Commons is larger than the House of Representatives. It's got way more than 435 seats. And that means Great Britain is more representative. And Canada has 1/10 our population. They've got something like 32 million people. And their House of Commons has 338 seats, 1 for every 100,000 people, instead of 1 for every 790,000, which is what we have. And the result naturally is a House that's not terribly representative, and also a House that is easily gerrymandered because there are a limited number of these districts to work with, and you can often, for partisan purposes, get the outcome you want. But if there are more districts, state by state by state, because there's more House members, if you just wanted to do it that way, then the opportunities for gerrymandering on a partisan basis would be more limited, because inevitably more seats would be more fairly representative. You couldn't just gerrymander all those seats.
And what would have to happen for that to take place?
All that has to happen is Congress has to pass a law. Nothing in the Constitution says you got to have this number of seats. And in fact, James Madison, who was a pretty smart guy, like all the way back in the 1790s, he thought we needed a constitutional amendment to make sure they keep increasing the size of the House, whether they want to or not. And he didn't get that, but that could still be done. But it would be far more easy for Congress to pass a law, as they used to routinely in the 19th century, increasing the seats in the House of Representatives. president would sign it. I think Joe Biden would love that kind of thing if he was still the president after November. But that, I think, would take care of a lot of the problem, and it would do a lot of other great things as well. This is beyond the topic a little bit, but more members of Congress means better oversight of the executive branch, better constituent services, and you feel closer to your representative because
Right. Yes.
It's, to me, almost a no-brainer. It'd be more expensive. You got to pay these people, got to pay the staff, but it's a drop in the bucket compared to
Right.
the other.
Well, unrelated to this particular topic, there's also the issue of expanding the Supreme Court too. So
Yes, which they could also do. That's certainly within the power of Congress. I like to see that happen. And the reason I think that probably should happen is they write these really, really long, involved opinions. Surely, if you had more justices with more clerks, if that's the way they're going to go about it, I think that the opinions could be at least better. I think there'd be more people looking at them, to be more editing, and
better
that's just
scrutinized, if nothing else.
yeah.
Yes. Anything else you'd like to add about the voting rights as we see them today?
Well, yes, because we're talking about remedies, and at the moment, the main point that Justice Alito made, and that the other 5 justices joined him in, was that as unfair as this is, as maybe bad for democracy this might be, there's nothing we can do because, as we said before, there's no judiciable standard. And there's some truth to that. Now, I think the best argument that the court made is it's really hard to know just how to say what is partisan and what is not. Like, where do you draw the line there? You can sometimes detect a racist motivation based upon transcripts and what people want to testify somebody else said. It's not easy, but sometimes you can do that. But how do you tell when something is too partisan as a gerrymander? And there are 2 things to be said about that. One thing is there might be a standard. And this was a standard that was proposed by plaintiffs in one of the Wisconsin cases that were very, very important during the second decade of the 21st century. So what you could do is you could look at the districts that have proceeded from an allegedly gerrymandered set of decisions. And you could find out, for example, if it's a packed district where we want to put all these Democratic voters here, they'll elect their candidate there, maybe nowhere else. But if it's a packed district, you find out what is the excess of the amount of voters Democrats need to elect a candidate. Like, how many extra Democrats are in this district? What is the extra voting strength represented by this district? And you attach a number to that. And if it's an excess of a certain number, like if it's above 7%, was one of the things that plaintiffs suggested, then that is an unduly packed district. So now you know that that's maybe too much of a partisan gerrymander, and you could do something similar with the cracked districts, although it would be maybe it's called an efficiency gap. You just calculate it differently. But what you're always looking at is what is the excess number or number that's below what it ought to be to fairly have a competitive election in that district. And if it's beyond a certain point, then it's a partisan gerrymander. So you'd have to heavily get into some math, but why not? Maybe if this is such a threat to our democracy, courts should actually consider something like this. The statisticians would love it. They'd have plenty of work, and the clerks could probably learn how to apply this. So there are mathematical ways to decide maybe how much gerrymandering.
But I mean, and why can't we just do this organically? You know, just where the chips fall where they may, let people vote in their counties. And why do we have to do all this? It seems so fake. So inorganic.
Well, I think you brought up counties, which is actually a pretty good point. One reason we can't do it that way is states have too many counties, and they did it that way for various reasons. One reason being to preserve voting strength in the areas that legislators like, by having all these counties with all these different officers and all these people they can elect. But as long as you've got 435 members of the House in that Saul, you're going to have far fewer districts, and that means you invite drawing the lines. And there are so many counties that you can draw the lines in all sorts of ways and still respect the counties. And if you go through the county, thus not respecting geography very much, the Supreme Court is very reluctant to call that a problem. Now, getting back to the South Carolina case, the new District 1 that South Carolina ordained in that case is actually a non-contiguous district. There's a southern part and there's a northern part, which is usually really good evidence that's a gerrymander. It doesn't make any sense. It's non-contiguous. To get from the southern part of District 1, you got to cross over District 6, which is downtown Charleston now. It wasn't before, but now it is. And then you get into the other part of District 1. But as long as it's not a crazy kind of gerrymander, usually the Supreme Court is not going to care much about that. So we're stuck with that problem.
Yeah, SHAPE used to be alarmed that something was amiss, but I guess no more. SHAPE of the district. Yeah.
And I think when you talk about these cases and how you might win them and what the Supreme Court thinks about them, the other worrisome thing to me about this is that the Supreme Court in this case, the South Carolina case, made it even more difficult for future plaintiffs to ever win them. And it's not just that you got to presume good faith on the part of the legislature, which is bad enough. And it's not just that you can no longer say states can't use race as a proxy for partisan affiliation, which is also bad enough. The third thing that's pretty bad is that the court essentially said that if plaintiffs are ever going to win this case, once we establish that as partisan gerrymandering, then the only way they can possibly win is to show that they could have had more Black voters in the district and had a greater chance to elect Republicans because of that. And that's the alternative map requirement. And South Carolina never had a map where, for example, they could look at District 1, say, we're going to have 19% Black voting age population there. And that will help us elect much more assuredly and more reliably a Republican. The opposite would obviously be true. So demanding an alternative map in this kind of case is asking the impossible from plaintiffs based upon that essential point that race and partisan affiliation tend to correlate. How could you ever have a map where there'd be more Black people in a district and a greater chance of electing Republicans? But if you don't have that map, according to Justice Alito, it's very likely you will lose.
Well, they had several maps and Justice Alito didn't like any of them. So
they had literally thousands of maps, all of which would have had more Black voters in District 1, and all of which presumably would have meant greater likelihood of a competitive race where Democrats might be elected. So that's not going to help the plaintiffs.
Right. And unfortunately, we know where Justice Alito stands.
Yes, all you got to do is look at the flag.
Exactly.
Probably not going to be much of a mystery.
Right.
So it's a depressing case.
Yes. And it's worrisome going forward. So unless the makeup of the court change and they overturn some precedent, which they have now been doing, things will remain status quo and not in a good way.
And if you want a slight silver lining, don't forget that Section 2 is still in the Voting Rights Act. And even this Supreme Court in the Alabama case from just last term said that Alabama violated Section 2 when they failed to have a second majority Black district when the demographics allowed them to. So that's not bad. They still think there is such a thing as the Voting Rights Act in Section 2. It's just that this South Carolina case probably doesn't raise the kind of issue where you would prevail as a plaintiff on Section 2.
Well, unfortunately, that doesn't leave the country in a very good place and doesn't make people confident that their vote will really count.
No, it discourages people. It maybe lets them stay at home, which itself historically would be pretty good for Republicans.
Right.
Like a high turnout among young people and minority voters and people enthusiastic about the process, city voters. And the more this happens, the more one discourages turnout.
I wonder what Madison would say if he were alive today.
He'd be unhappy about the whole thing. I think he'd be profoundly discouraged.
Yep. So much for originalism.
That's right. Oh, exactly. So much for originalism. Very good point. Why not bring up history? This is a great case in South Carolina to bring up history. They've been drawing maps based upon racist presumptions for a long time in South Carolina. Why do we assume good faith on the part of this legislature? They haven't done anything to justify that. So if you're going to bring up history in the Dobbs case and talk about how we shouldn't allow abortion because back in the 14th century, Henri de Bracton didn't believe in abortion, why wouldn't you talk about more recent history with Reconstruction and Jim Crow? But that's just not something the court did.
Right.
Mhm.
It didn't suit the purpose.
No, it didn't suit the purpose in this case. So moving forward, support people who want new progressive ways of electing people, independent commissions, maybe increasing the size of the House. And I think that would go a long way to solve the problems. They seem visionary now, but all sorts of things have seemed visionary in
And
the
the
past.
Supreme Court, yes.
Yeah, and
Increase that too.
Increase that too. That wouldn't be such a bad thing.
Right. Well, thank you very much for joining us. This has been an enlightening discussion. And I look forward to another time when we sit down and talk some more.
Yes, anytime. Thank you very much. This was fun.
Thank you very much, Dr. Breen. I want to thank our guest for sharing his insights and information on American history and the law. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guest, visit us online at thelegaledition.com. As always, this information is for general educational purposes. It is not to be construed as legal or personal advice. And please consult a qualified practitioner as to your legal or personal needs. And don't forget, subscribe online. Find us on Facebook, YouTube, Instagram, Twitter, now X, and subscribe on Substack.